Recent research has unveiled a disconcerting truth. A U.S. military veteran has suffered rights violations at the hands of the very government he once served. This unfortunate experience is a direct consequence of the federal government's decision to incentivize state governments through the Title IV-D Child Support Program. This program ensures that the state government receives 66 cents for every dollar collected through the Child Support Initiative, leaving those who fought for the preservation of freedom and liberty without recourse for the violation of their constitutional rights. For nearly 6 years, this veteran, who enlisted just 3 months after 9/11 and subsequently served during Operation Enduring Freedom, has been subject to defraudment by the Florida government. Indefinite suspension of his driving license and vehicle registration, coupled with exorbitant financial demands, including $20,000 for the opposition's attorney's fees, over $50,000 for fraudulent child support arrears, a $3,000 purgative payment, and a withheld $7,600 tax reimbursement, exemplifies the depth of the violations. The transgressions that are being referred to begin when the veteran's former attorney, who was handling the case, failed to take into account several critical factors while determining monthly child support obligations. These included Delaware state tax, Wilmington city tax, and mandatory retirement salary deductions. The attorney's negligence was a clear breach of Florida Statute 61.30, which outlines the requirements for calculating child support obligations. This initial error had far-reaching consequences and led to a series of egregious instances of judicial fraud, violations of the color of law, and civil rights infringements. Those who were entrusted with upholding justice were found to have engaged in blatant fraud on the court, which is a serious offense in the legal system. The consequences of these transgressions were significant to the veteran who was relying on the justice system to protect his rights and ensure fair outcomes. The current state of the court system is a matter of grave concern, as it has been observed that the pillars of the system are being used as platforms for fraudulent activities, injustice, and corruption. It is worrying that these issues have become so widespread that they are now forming the foundations through which laws are being manipulated and abused. One example of this is the Florida government's prioritization of efforts, which is not only defrauding veterans but also extending to defrauding the United States government. This is a serious matter as it not only affects the lives of veterans but also puts the reputation of the government at stake. It is important to address these issues and take necessary action to restore the integrity of the court system and ensure that justice is served. Officers of the court would not only admit to the omissions but would indicate that the calculations and verdicts were temporary and that one judge would allow for compliance with the law at the final hearing. However, the court continued to reject Florida Statute 61.30 but the judge, acting under the guise of law, refused to align his verdict with Florida laws. The judge would instruct the veteran to file an appeal of his verdict, which served as an unmistakable indication of bias. Although complaints were lodged with various authorities, most dismissed allegations of fraud because they believed that fraud did not exist due to the attorney's admittance of her actions. However, 6 years later, the omitted salary deductions remain unacknowledged. The legal system, particularly the family court, has faced criticism for its lack of accountability and transparency in the actions of attorneys and judges. This has perpetuated a cycle of injustice that unfairly affects non-custodial parents during the calculation of child support obligations. The recent example of the federal government issuing 66 cents for every fraudulent dollar collected through this military veteran's monthly child support obligation highlights the flawed system in state courts. It showcases the contribution of state courts to a fundamentally unfair system that perpetuates the cycle of injustice. It is noteworthy that the second judge, despite knowing known omissions in documents, not only allowed them but also increased the military veteran's fraudulent child support arrears by $3,000. To make matters worse, the judge labeled it as a purge payment, which is simply unacceptable. It is shocking to note that this judge rejected Rule 60(d)(3) principles, which serve as the guiding principles for such cases. The judge further asserted that there is no statute of limitations for fraud on the court, which contradicts the law. The second judge's decision to support the recommended order of a second general magistrate was even more alarming. The magistrate had threatened the military veteran with arrest for non-compliance with the violation of his 14th Amendment rights. It is indeed unfortunate that even after the military veteran informed the Department of Florida Revenue about the fraudulent calculation associated with the child support collected for over a year, his driver's license and vehicle registration were indefinitely suspended. The suspension of his driver's license and vehicle registration made it extremely challenging for him to transport his 2-year-old daughter for necessary visits. It is worth noting that this narrative is not an isolated incident but emblematic of a pervasive issue affecting non-custodial parents, transcending gender stereotypes. It is, therefore, imperative that the child support system be reviewed and reformed to address the systemic flaws that are causing such injustices. In conclusion, this poignant account calls for a comprehensive examination of the flaws within the Title IVD child support program and the broader legal system. The journey of this military veteran is not solitary. It echoes the frustrations of others entangled in a system that demands scrutiny, reform, and a commitment to justice.